My name's Tom Cohn. I'm with the law firm of Venable in New York. And with me today are David Katz, who's Vice President of Corporate Development and General Counsel of Cyberplex, and Dean Graybill, the Assistant Regional Director of the Western region of the FTC based in San Francisco. And David's based in Toronto. Thanks again for coming today. We're going to run through a lot of different issues with law enforcement risks. There's a lot happening in the space right now, just in recent weeks and months. And I'm going to start off by giving you an overview of kind of advertising law 101, which some affiliates know about and some affiliates don't. But it's useful to go over these points just because it's what both the FTC and the state AGs, whose laws kind of mirror the FTC in many respects, it's kind of what they look to when they look at practices out there that they think might be violative. So it's good to know these advertising law principles first. So I'm going to jump right in, and as I go through this stuff, you should know my background is 17 years with the FTC, including Assistant Regional Director and Regional Director in their New York office. So I'm going to do quite a bit of FTC kind of 101, ad law 101, and I'm going to invite Dean to jump in at any time as we go through this. And we're each going to take about 15 minutes each, and then we'll save the last 15 minutes for questions. Thanks. These two, I'm going to stay down here. These two laws are really the backbone or the foundation of everything the FTC does in terms of consumer protection enforcement. Section 5 of the FTC Act prohibits unfair and deceptive practices. Section 12 of the FTC Act prohibits false advertising. Everything that they enforce really stems from these two laws, these two basic laws. Deceptive is different than unfair. This is the test for when is an ad deceptive. Material misrepresentation or omission of material fact that basically leads consumers to act to their detriment. Unfairness is a different test. It's basically consumer injury that's not reasonably avoidable and not outweighed by countervailing benefits. I'm sorry? If we go to the podium? Okay. Is it okay if I stay here, though? Yeah, okay. I think I'll just stay here. It's a little easier for me. The important thing to remember is that these basic standards, the FTC considers them applicable to all media channels, all forms of commerce, and these laws have been around for decades. So as things develop from telemarketing to direct response marketing to internet marketing, the FTC really applies the same principles to these new situations, and that's important to remember. In terms of the basics of advertising law, here's some points that just to remember. An ad can be literally truthful and still be deceptive. There are such things as deceptive omissions. Fine print disclosures aren't going to cure otherwise deceptive ads. And then I'm going to get into clear and conspicuous and what the FTC means by that. They have a shorthand, which is the 4 Ps, and that's prominence, presentation, placement, and proximity. And we'll get into some specific examples later. This is some guidance that the FTC came out really at the point of, I guess I'd call it Web 1.0. These are staff guides for industry on how to comply with the laws the FTC enforces when doing online marketing. I think they're probably due for a revision if they're 10 years old, but they're still good guidance. This came out in May 2000. And there's a lot of, this is all at FTC.gov as well. There's a lot of guidance about hyperlinks in particular, and what they should look like, where they should be, and they need to be effective. In terms of clear and conspicuous, these points come up a lot in terms of both disclosures or disclaimers that are going to modify product claims, but also that are going to modify marketing claims, especially negative option and continuity rebilling sorts of statements that are being made. This is applicable to all of that in terms of modifying both product claims and the marketing statements that are being made. The FTC looks at the net impression of all of it on the page and how it all works together. And the disclosure in general should be in the same format as the claim that it's modifying. So visual, visual, audio, audio. In terms of when a claim is deceptive, this is pretty much the test that the FTC applies, and it has to be a material claim, but that's presumed for a lot of categories. And the FTC never has to prove intent to deceive because it's not like a common law fraud claim. They can prove deception even without any actual intent to deceive. Claims have to be substantiated. This is very important with particular product claims and a lot of verticals like dietary supplements especially, and in different inquiry when it's biz ops and earnings claims are being made. But substantiation, you have to have substantiation for the claim before you make it. That's the cardinal principle. And it has to be competent and reliable evidence in most cases, but if it's a performance, efficacy, health, or safety claim, that has to be, the substantiation for that must be competent and reliable scientific evidence. And there's a lot of FTC cases in this area in both health products and other type products. And here's just a laundry list of sort of what is and what is not considered to be competent, reliable scientific evidence. And again, I remind you with dietary supplements in particular, some of the FTC cases in recent years have focused on the marketing practices, the inadequate disclosures for continuity, but if the FTC brings a case based on that, they invariably are going to add on product-related claims as well if there are false or unsubstantiated claims being made about the particular product. So you have to think about both at the same time. There have been probably hundreds of FTC internet marketing cases in the last 15 years. Recently, there have been a lot of cases involving allegedly bogus cancer cures. Flu and cold cases have been active in recent years. The FTC is working more with the FDA in joint coordination, issuing a joint warning letter last year for the first time. In terms of priorities, I think it's going to continue to be more of what we've seen in terms of the perennial weight loss cases, all sorts of lethal disease, cancer, diabetes, other cases, products marketed to kids, and the grant debt, work from home. To that, I would also add things like payday loan, foreclosure rescue. The whole category is, you could think of in terms of poverty, recession, recovery, stimulus. That whole area, the FTC and the state AGs have really been highly scrutinizing in the past year or so, and are going to continue to do so as long as we're in a recession. I'm going to ask Dean to chime in here where he likes. The FTC has a set of guides. They're not laws or regs, but they're guidelines called the endorsement guides, created in 1980, and they were just revised for the first time this past fall. Basically, you can't say something through endorsements or testimonials that you couldn't say yourself as a product seller.
Yeah, just when I get to my part, I think one of the themes you're going to hear from me repeatedly will be use common sense. And I think it's funny, one of those areas that sort of begged for a reexamination was this idea of consumer testimonials. Everybody in this room has seen, extreme weight loss consumer testimonials, or, oh, I got rid of my cellulite, or I got this, these extreme claims. And then there'll be this little, if you see it, there'll be this little disclosure at the bottom, oh, results may vary. And you had to ask yourself now, how effective, but let's say the truth of the matter was that 98% of people get either no weight loss or have to exercise their butts off, or maybe very, very modest weight loss. Do you think that dramatic presentation of this obese person, plus this little, oh, results may vary, adequately paints the picture of the true efficacy of the product? We finally just said, you know what? And we actually did some consumer perception studies to see how effectively some of these little disclosures were being, and we pretty much found that results may vary wasn't telling any people anything. And so now the guides have been changed to say, among other things, if you're using quite a typical example, you can't get away with this results may vary stuff. You've got to then, that triggers a duty to affirmatively tell people what the representative ordinary experience really is. And I think you'll find that for many of these bogus diet pills and so forth, that's pretty much a poison pill for making the claim at all. I'll also talk a little bit more about another interesting, I think, sort of hot topic in this area is blogs and disguised commercials. Because another part of the guides is you're having to disclose if we call it a material connection, but have you been paid? Is this an advertisement? Is this a sponsored advertisement by a seller in disguise? And I think we've all read about the mothers at home who are getting, weekly free products, from particular brand makers, and they're making these blogs, given the supposedly objective. Oh, I've tried all sorts of detergents, but man, this one really has kept my clothes clean. And it turned out that they're being given free product to say that, or being paid outright. They now have to, even bloggers, have to now disclose the fact they're being compensated. So I would just say those are the two high points. I guess would you agree those are the most important? There's some other aspects. But.
Yeah, taking away the results may vary safe harbor is the one high point, and the other is disclosing material connections. As Dean said, the FTC made it very clear now with the revised guides that applies to online as well as offline situations. Now, are they going to go after every mommy blogger? No, they're not. But if there's enough of a problem with any one particular blogger or acting in concert with an advertiser especially, the FTC's made it clear that they could possibly go after both the advertiser and the blogger for not disclosing that connection. So that's important. And in terms of affiliate marketing, I mean, obviously the whole model, the way you're being paid is, the advertiser is paying the network, which is paying you. So that, existence of that material connection, how you're compensated itself, obviously should be disclosed on all affiliate marketing pages as well. I'll skip over expert endorsements. This is really important because the FTC for decades has really been saying this even before there was an internet. Everybody and anybody in the advertising stream, if you will, could conceivably be held liable. Certainly in years past, there have been cases where the FTC has named advertising agencies, sort of 20th century style advertising agencies, based on a knew or should have known standard. So the big question mark is, in terms of internet marketing today, what sort of third parties might the FTC or a state AG seek to hold liable? It's a big question mark right now, and obviously the FTC is not going to say up front, what they might do, but they definitely want the word to get out that everybody, could conceivably be held liable based on what's being done and who knows it and when they know it.
I don't think the FTC is open to suggestion either, right?
Oh, we're open to suggestion.
Sure.
In terms of consequences of deceptive advertising, FTC ad cases, they really vary. They run the gamut from national advertising cases against, Airborne, and then Rite Aid and CVS for private label versions of Airborne, where there's, huge dollar amounts. But there's also been plenty of internet marketing cases where they've shut down allegedly fraudulent operations and seized assets and gotten money back for what they believe are the consumer victims. So the FTC has really broad authority to go into federal court on their own and get these kind of extraordinary remedies. Now, I just want to jump into sort of like how we came to this point in terms of affiliate marketing. I would say right now the state AGs are probably in front of the FTC in terms of knowing how it all works and investigating what they think are problem areas. I tried to look back 5 years and find what I thought might have been the first examples of something like affiliate marketing in an enforcement action. And I guess you would say it was the first canned spam cases where there were affiliates out there engaging in canned spam violations. But then you get up to Florida AG 3 years ago with the ringtones cases. Also what I would call affiliates operating in those spaces with networks. And big settlements came out of that. And then you get up to last year where the FTC, to my mind, really went after affiliate marketers as principal defendants it was a unique situation where they were basically using sponsored search results to impersonate a government agency that had recently been set up to provide mortgage assistance, foreclosure assistance. And the paid search results had the full government URL in them, and if a consumer clicked them, she was taken to a site selling paid foreclosure assistance services. Those sellers were not named in that suit. It was the 9 affiliate marketers who were named as pretty much John Does because the FTC didn't know at the time they filed the suit who they were, but they later found out by talking to networks and others. And so that was really the first example, I think, of going directly after an affiliate marketer. It was a unique kind of narrow fact situation, but I think it's instructive for where the FTC might go in the future in terms of possibly going after affiliate marketers themselves. Like I said, the AGs are out in front. I know Illinois AG has named affiliate marketers in a state lawsuit. Other state AGs are investigating. And I would just say that the regulatory scrutiny has really ramped up in the last 6 to 12 months. And certainly, in the private sector, you all know about probably the Oprah Dr Oz lawsuit filed in August of last year. That was really a perfect storm of kind of like 3 different situations combined with allegedly false endorsements, infringement, as well as product claims that were false and unsubstantiated, as well as deceptive marketing claims in terms of continuity disclosures not being adequate enough. So it was those 3 areas together that led to that lawsuit. But again, the state AGs as well are looking at looking at those areas as well. This is in your handout that I distributed, and this is really taken from typical agreements between networks and affiliates and written agreements between networks and advertisers. It's all common sense stuff. You've probably seen phrases like this in your agreements. And then I listed similar things for merchants and networks to be aware of. I think at this point I want to turn it over to David to give you a business perspective from the standpoint of a network dealing every day with both advertisers and affiliates.
Right, thank you, Tom.
Sure.
Is this working? Okay. So initially when I started preparing for this talk, we tried to put together, I guess it was, I don't know if you have it up there, Tom, but it was based on searches we did, and John Moncrief, who works with me, did most of this actually, finding sort of the bad things that we're seeing affiliates do out there online and putting it together into one big horrible bridge page that we thought would be kind of fun to look at. But I was a little concerned that we were just lifting content off of these bridge pages without permission. But then I thought to myself that there's probably no one here that will speak up and claim ownership to this in front of Dean, so I'm probably safe. That was about 6 weeks ago or so. Truthfully, a lot has happened in the space in the last 30 days, really, that has changed a lot of behavior and is really the first real signs of self-regulation that we're seeing in the industry, which I think is long overdue and is the type of thing that will preserve the longevity of what we're all doing if we can recognize that there's tremendous opportunity in this space still. But we've got to use, as Dean says, common sense. And so I'd like to talk a little bit about, from the network's perspective, what we see and what we think is going on. So generally speaking, consumer protection is at the root of all legislative activity right now, as it relates to the marketing of products and services online. And networks serve 2 key constituents, as we know, advertisers and affiliates. And both of these clients of the network have a relationship with the end consumer. The publishers obviously generating interest for an advertiser's offers, and in some cases through the use of bridge pages, elevating their role to almost one of a trusted advisor, warming up that person for the conversion. Advertisers develop their relationship obviously on sale and when the person visits the landing page and acquiring that customer. Networks themselves facilitate this indirect relationship between the advertiser and publisher, but generally do not establish their own relationship with the end consumer. And the problems occur when some advertisers have abused their relationship with the customer, either through inadequate disclosures, defective product claims, poor customer service and fulfillment, and questionable, if not, downright unfair billing practices. On the affiliate side, similarly, false, deceptive, misleading claims, inadequate disclosures, infringement of third-party intellectual property, and other tactics designed to increase interest in the advertiser's offer. While these types of advertisers and affiliates are truly in the minority, the impact on consumers has caused increased scrutiny across the entire industry. So where advertisers and affiliates, these types, act in this manner, there is and ought to be accountability for their actions, and accountability should reside with them, not media sources, not networks, ISPs, banks, Microsoft because you used Word to create the document. Like, you got to be accountable for what you're doing. And so why are we talking about enforcement risks impacting networks? Well, where the networks start behaving like advertisers or publishers themselves, doing a lot more than facilitating this connection, but actually conspire or knowingly contribute in a meaningful way to the consumer harm, then there's risk. Whether what the test is, I think, is up for debate and where that'll end up. But I mean, there are some clear lines here. And the bottom line is that a network or any other media source can't merely turn a blind eye to bad advertisers or publishers with specific knowledge of wrongful acts of a certain affiliate. Allowing those wrongful acts to continue would not be without risk for the network. Now, most networks do take steps to ensure that liability for these types of activities are apportioned to the wrongdoer, and Tom showed some examples of that. These are basically, more often they're contractual, reps and warranties, terms of service, attestations, and other assurances, but that's only going to go so far. I mean, clearly, as between those three parties, it can apportion liability, but if you know of something that's happening, a specific incident, and you don't do anything about it as a network, I don't think you're going to be able to just hide behind that apportionment of liability, certainly not as it relates to third parties. A third-party regulator or private party will not really care how the three of you guys decided to divide up your liability. They're going to go up and down the chain. And so there's always going to be liability on the players, even at a minimum if it's defending yourself, which is not something anyone's really keen on doing. Where's the line? I actually don't believe that testing legal theories of network liability for acts of publishers or advertisers is the goal of regulatory authorities or private industry. And the networks don't really want to litigate that issue. Regulators want the bad practices to stop. Brands want their trademarks protected. And networks are interested in maintaining a sustainable business practice within the industry. And to that end, we've already seen self-regulation underway. It's not necessarily this threat of regulatory scrutiny that's motivating networks to become more active in trying to prevent these types of activities by these independent advertisers or affiliates, but rather it's far less academic than that. If consumers are harmed by acts of publishers or advertisers, consumer complaints and chargebacks will be the result. Where that becomes more prevalent, merchant accounts will be at risk. If advertisers lose the ability to process business and access their funds, networks won't get paid. And if networks don't get paid, neither will publishers, and the whole ecosystem will crumble. And I know it sounds like a theory, but as many of us know, this is happening already to some people out there. And it's the single biggest driver of industry self-regulation by networks today. Not necessarily the threat of the FTC or Oprah or anything of that nature. Look, if you're not going to get paid for what you're doing, you're going to stop doing it. And I think that's really what's driving change right now. The entire, looking at law enforcement though, I mean, the entire industry has garnered a ton of attention and scrutiny over the past 12 months. Really, it's been a victim of its own success, as well as the activities of a few bad seeds out there. And until recently, there's been little self-regulation, but now we're seeing compliance is really being sought by more than just legal regulatory bodies. The pressures to self-regulate from both private and public interests are beginning to take hold. And to date, public-private partnerships are leading the enforcement initiatives. And examples are the joint initiatives by the Federal Trade Commission, credit card issuers, Better Business Bureau, state AG actions seeking consumer redress, but brought in partnership with private industry seeking trademark protection. I don't think it was coincidental, the AG action and the Harpo claim happening, same day, same hour, same minute.
It was coordinated between them, yes.
But again, it's really the business realities of what's happening at the consumer level that's quickly filtered through the system, causing change to occur very fast. And in short, everything is hitting at once, and the response has been very fast by some leading networks, advertisers that are very active in this field, and it has been coordinated as well. And looking at how the landscape's changing, a few of the leading networks have worked closely together to implement measures as it relates to advertiser conduct to ensure that certain standards are being upheld by advertisers looking to benefit from the power of affiliate marketing. And networks, similarly are continuing to try to find ways to tighten acceptance criteria for affiliates and publishers and to screen bad ones before they get in. Because we all know once affiliates do become active, it is difficult to monitor. Well, if not, it's certainly mission difficult to try to find out what everyone's doing on their respective bridge pages, where they're buying media. It's endless, and it's not something that networks can afford to make a sort of a standard business practice in a very comprehensive way. So it's very important to find this before it happens and before people get into the networks. Advertisers, though, are less sympathetic. They're increasingly putting pressure on networks to monitor wherever possible and to take responsibilities for the acts of publishers where feasible. And many of us are aware of the difficulty in monitoring acts of publishers, but certainly publishers who demonstrate that they're not willing to run compliant traffic or have a reputation for producing bad traffic will have a difficult time finding a home with any reputable network or buying media for that matter. So there are some technology solutions that will help network try to keep up with the publishers, but that's a work in progress. But the key is reputable networks will be looking for publishers who themselves want to run compliant traffic and themselves want sustainable business for themselves. So that's the way the market is heading, and at least that's the way we see it heading, and it's heading that way relatively quickly. Now, why is this good? The success of affiliate marketing, we all know. It's a young market, it's small, relatively speaking, and as the industry matures, which is happening in real time, brand advertisers will become more comfortable participating in this marketing channel, and the dollars that will flow into affiliate marketing really will dwarf anything we've seen to date once that happens. So we should all want that to happen. And we already are seeing signs of it. Less aggressive marketing tactics by advertisers, especially through continuity billing and upsells, will lead to more sustainable payout levels. Quite frankly, some big brands just can't compete with the payouts they're seeing because of the types of campaigns that have been prevalent for the last 12 to 18 months. But as brands do come into the space, brand trademarks convert. We know that. We've seen that. More media will be available for these offers. Less selling will be required on the bridge pages in order to get conversions. In our network, we're already seeing some of the better publishers investing in some of the brand campaigns that we have and producing steady and dependable income from those offers. So, we're seeing some of it, which I think is a good sign. It's a little bit of a shame that it took all of these pressures at once to hit for us to start seeing change, but we as an industry are much better off self-regulating than having someone else do it for us. And I think that's a fair statement. So, what this means for the industry, I think, is that, compliance pressures are reshaping the industry, but there's significant opportunity with this change. The changes will protect the longevity of the industry, and affiliates who continue to be non-compliant will be subjected to direct enforcement, I think, specifically the bad players that are most out there, and significant liability. And affiliates who are creative and use sustainable marketing practices in the face of these changes, I think, are really going to prosper. So I think it's really a time to invest in your business and to find a way to channel that creativity into something that's really sustainable.
Great. Thanks, David. Dean, do you want to give us the FTC perspective, both in terms of recent cases that might be of interest and where the FTC might be going from here?
Happy to. I guess actually I have to, every speech I have to give a disclaimer that I'm basically a middle manager, and I'm not the one that makes policy at the commission, so if I express certain opinions on what's going to happen next, it's mine. Don't assume that this is speaking for the commissioners. They may have a different view, but I'll just do my best for my part. One thing I'd just like to start out by giving a little research tool. The FTC.gov is a tremendous resource of knowledge and education and warnings, business educational warnings about affiliate marketing, all the topics that have to do with the things they do market. And for example, one little tip, go to FTC.gov, look in the little tabs up front and look for news, and that'll get you into every press release that the FTC has done. And it's a searchable database, so if you type in affiliate, you'll draw up a lot of activity that's happened. You'll get up speeches, probably. You'll get up press releases for cases we brought. If I happen to mention a case in the course of my talk here, if you type in Grant Connect, that's a case I'll talk about, you'll see the press release for it, and you'll see the complaint online. It's a tremendous resource, so if nothing else, try to remember that. That's how I do my research on what's happening at the FTC, because I can't keep ahead of all of it. I want to reinforce what both my compatriots here said, and that is to say, the FTC, we're sort of, it's not our job at the FTC to make any judgments about what forms of marketing should happen in this country and what shouldn't. We're equal opportunity employers in that regard. We sort of take it as we see it. Are consumers being deceived by the marketing technique of the day? We have no stake in seeing, if affiliate marketing can become a fruitful way of getting the message out for good brand names to consumers, fantastic. We're very neutral that way. But at the same time, my message today would be to say, because we encounter we've brought a lot of online cases, and that includes in our San Francisco office. And it's funny, I met a lot of defendants, and it's funny, many of them are very young, and we just very often encounter a sort of worldview where it's almost as though they feel, well, look, the online world is different. I know that if you misadvertise a Cadillac on TV under old advertising, it's got to be the fuel economy things have to be this and that. But it's almost like this laissez-faire sort of, this is a different world. It's not. It's a world where we apply the same common sense principles and the same enforcement techniques as we apply in every other industry. And as was said here, I realize that there's so many variations. I've done some reading in this area. I can't even get my label straight. Who's the affiliate? Who's the advertiser? Who's the publisher? I think I got it straight. And I understand that sometimes there's also just firms that are sort of middle managers, as it were, who both recruit sellers to sell goods on their network and then also recruit the, well, I would call the affiliate advertisers to sell those goods. It's almost like they link people together. And they may not write ads themselves, which is the obvious case where you might be liable. They may not sell the thing themselves, which is another instance where liability would seem obvious. But yet, they're in the chain. And a matter of fact, they may be the ones that are responsible for, getting this whole thing started. And so for anybody in the chain to just assume that I'm just a techie putting people together, I can do this hear no evil, see no evil thing, that's over. And I'll just give you an example of a case. Tom rightly pointed out one case where we went after affiliates. There was a case, I think it was this fall, called Grant Connect, where we really went after practically everybody in the chain. And I'm just describing what's in the complaint. But as I understand what was in the complaint, okay, this was like, there was this Obama campaign of making, mortgages more affordable and so forth, government campaign. The firm at issue was purporting to sell a private sort of, I'll link you with government, government grants. Well, the seller of that purported bogus service, we named them. We also named what I would call the sellers at the back, the downstream, the people who were putting up websites. Here, there was a number of different websites. The seller of the Grant Connect was putting up its own websites, but it also then had affiliates who were purporting to sell things like credit cards, except when you tried to buy those credit cards, you didn't realize in the fine print that you were signed up to a continuity plan for the supposed grant service. Okay, so you had affiliates who were driving business to Grant Connect. We named them too. We also named two firms here in Las Vegas who had recruited, who at least are styled in the complaint as being firms that I would call a network that sort of put the seller and Grant Connect together. We also named individual officers and owners, and that's one thing we do in FTC cases. Now, there's different legal standards that apply and so forth. I can tell you this, if you look at the cases we bring, that we have brought, I think it's frankly every case we bring, you might think, oh, wait a minute, I thought I'm incorporated. Isn't corporate form supposed to shield individual liability? There's a slightly different rule in FTC cases, and that is you can actually get money from an officer or an officer of a company if that officer pretty much knew or should have known that the company itself was doing something wrong, and they either actually knew they were doing something wrong, they should have known it, and here's the important point, or they consciously avoided knowing. That's a very interesting concept, and I tell you, that's one of those little touchstone things we see in all of our lives, with friends, with personal relationships, that I'm just going to avoid knowing what my sister is doing, or I'm going to, we take all that stuff into account, but I think if you look at the cases we bring, I think most people would say, yeah, I can see that. We don't go after extreme, we don't tend, as we build law in areas, we don't tend to go after extreme instances where there will be huge debate about whether this firm ought to be held liable or not. And that's, I guess, that's the comforting message. But at the same time, I just want to make it clear that everybody, we go after payment processors in telemarketing cases, And you might say, now, wait a minute, why should a network possibly, that's just sort of getting people together? Well, they may be the ones that are responsible for recruiting some pretty bad actors, or they may be in a position where they're in the payment process, and they're the ones that see chargebacks because they don't get paid, depending on what their arrangement is, if the sale doesn't stick and there's a refund, or and we're in litigation right now against a firm where there were thousands of chargebacks. And thousands of consumers refusing to use the stupid, ancillary product that they didn't know they bought. Everybody in chain may be quite aware in a position to know that. So there's a certain logic in in us looking at everybody. But at the same time, you know, I've worked at the FTC almost 30 years. We are not an extreme organization. I think if you looked at the cases we brought, you would probably nod your head and say, yeah, you should have gotten those guys. And there's one reason for that. You know, we go into federal court in our cases. And we have to persuade judges that what we're doing is reasonable. So, as was suggested, we're not a bunch of wild-eyed, you know, crazies. We try to pick responsible cases, but I just, nobody's exempt from reasonable scrutiny. I think that's one thing that should be said. One pet peeve of mine, and that has been mentioned already, we just see it again and again and again in online cases, not just affiliate marketing cases, but all sorts of online cases. This fetish with thinking you can save a misleading ad with fine print disclosures. Now, one real problem we see a lot of is these continuity plans. We had a case against a firm here in Las Vegas where it was one of these things you see, you know, free offers. It was free internet shopping spree, free. I forget what else it was. And what you didn't realize was that you were inadvertently signing on to a continuity plan to buy Hoodia or some diet thing. And all at once people, and that, you know, meanwhile people had given their bank information thinking they're going to pay a shipping fee of $5, and all at once they see $150 charges on their bank account because they were signed on to this three different continuity plans without them knowing. Well, you know what? There were disclosures in those ads, you know. We have a case against an outfit right now that sold a debit card. They purported to be selling payday loans, and when you went to the site, you know, you fill in, I want a payday loan, so you put in your bank information, all this stuff, and then it would take you to another page, and it would say at the top, well, you might want to consider these things. And there was this maze of offers and little radio buttons and this and that, but it said, if you want your payday loan, submit. You went down and you submitted. What you didn't know was that one of those little offers up there was pre-clicked for a card, which nobody wanted anyway. That's a little editorializing there, but and all of us people's bank accounts are being charged. We're in litigation right now against that firm. We've already settled with the offerer of the card. The affiliate, or well, at least the third party, what I would call an affiliate marketer, is one of the defendants. Another thing about disclosures that I see again and again is that it's not only not seeing the stupid thing, it's the content. You know, you'll have an ad. I've litigated against debt negotiation firms. You know, the ones that, I take your credit card debt from $50,000 down to $20,000. You know, it's an easy, right? You know, it shows, you know, first 10 pages of the website will show, you know, green trees and people looking happy. Oh, they're stress-free. They're, you know, oh, we have established relationships with credit card companies. Oh, this is going to be an easy ride. Forget bankruptcy. That's hard. Then on page 10, at question 9 of their frequently asked questions, it'll say, can I be sued by the banks if I stop paying them under your program? And it'll say, well, yeah. Well, in the case we brought, there was 18,000 clients, 5,000 of them got sued by their credit card company. They paid $40 million in fees. 75% bailed out because they realized this firm isn't protecting me at all. They never had to deal with the banks, you know. So you've got a main message that is entirely contradicted, less effectively, by a later fine print disclosure. I see this all the time, and this is where I say, you know, if you look at Tom's, you know, his PowerPoint. You know, it goes on, and if you'll read this .com disclosures booklet, which I really do recommend you read, there's a lot of little rules in there. And you might say, man, this is a bunch of pointy-headed lawyers subjecting us to all sorts of this maze of rules. I mean, I didn't go to law school. You know what? In the online world, it's just an expression of common sense. It really is. It's just, we shouldn't even have to say this stuff. It's like, you don't put, you know, When you say something is free, you don't, on page 1, you don't put on page 10 in fine print that, well, it actually cost you $2,000. You know, I mean, we actually, you know, we say stuff like that in that .com's book, like it's a little rule, but you shouldn't have to, you know, people shouldn't have to be told that. It's common sense. And if you use your common sense, I tell you, you don't have to worry about the rules. I mean, people in this room are a lot more savvy than me in terms of divining the little ways that a disclosure here, or a placement, or proximity, or color up here, or distractions here, audio and visual, you know, all those ways that you can modify a consumer's perception or take away from the ad. That's how you got, many of you who do that side of the business, you know, that's how you make your living, and you've more sophistication in it than I'll ever have. All the FTC really says is bring that same sophistication to a basic question. Is there a significant minority of people that are going to be misled by this? Or they're going to jump from page 1 to page 10, because that's human behavior. Or, you know, apply common sense. And I swear, you've solved 95% of your problems. This is not the tax code we're talking about. It is really, the FTC's basic statute is don't commit unfair or deceptive acts or practices. It's like one sentence. We elaborate it with guidance and with cases, but common sense is what it's about. And in that regard, I would just say, well, I'll just close in about 3 minutes. You know, and again, I'm not attributing this to anybody in this room, but again, we run across a lot of people that it's almost, I once met a defendant here in Las Vegas who took over a firm, sorry about that, took over a firm that had been really bad news. And I think this guy had been a businessman and so forth. And he took it over, and he didn't really change the practices that much. And I talked to him, and he looked at me like, and I got the feeling from him that he views commerce as almost like an adversarial game with consumers. It's almost like, okay, look, caveat emptor, buyer beware. You know, it's my job to sell. It's their job to protect themselves. I just got to do this little legalese thing here. And if they don't find that disclosure, that's sort of their fault. You know, it's almost a game of hide and seek sort of approach to commerce. And all I would say is, if that's what you got to do, if that's the game you feel you got to play to sell this product, I suspect there's a problem, and the red flags ought to be going up. And you know, I'm not going to say that any of the categories I'm going to mention are all bad. But if I was trying to do some due diligence in either rounding up sellers to put on my network, or rounding up the sort of affiliates who tend to promote certain things, and I want to bring them in as advertisers. I mean, one thing I would do is, you know, I would do a search engine thing and say, what's happening with these types of offerings these days? Should I be looking deeper into whether there's a problem with what this guy wants to sell? And I can just tell you, I'll just say nothing more than FTC has put a lot of cases in a number of areas, and we see a lot of affiliate marketing in this stuff. Foreclosure, rescue, and home loan modification. These guys have mentioned some of these. Foreclosure, rescue, and home loan modifications. Credit card debt negotiation, just debt settlement, the thing I just mentioned. Again, I cannot pronounce this. What are the berries?
Acai berry.
Acai berries. Diets. Work at home opportunities. Now, there are legitimate work at home opportunities. I'm not, you know, again, like I said, the FTC, we take them as we see them. You know, there can be good ones, there can be bad ones. But my antennae would be going up. And government grant offers, we bring cases all the time on that. Because the thing about the problem with those things are, you know, yeah, there's grants, but, you know, A, there ain't a million of them. B, are they available to the ordinary person on the street? You know, very often not. You know, it's more complicated than that. Anti-cellulite creams, extreme diets, get-rich-quick schemes that just sound like, you know when you see them. Acne cures, I mean, even travel packages, depending on, they can or cannot be, you know, cures raging, cancer and diabetes cures. Again, cures. I'm sorry, nobody's cured these things yet. I wish they had. Continuity plans. People got to really I can tell you the FTC is really serious about people understanding continuity plans better, negative option things.
Didn't the FTC come out with some guidance on online
Yeah.
marketing in terms of continuity disclosure?
Yeah, there was something published in January,
year.
proposed, I forget what the status of it is, but you know, it's the basic thing of, you've really got to let people know with a baseball bat that they are into a negative option situation where they have to act in order not to be subject. That's not an exhaustive list. If it ain't on the list, don't assume that your due diligence is done, but you know, it's, the watchword is in this realm, common sense applies, and FTC looks at this like it looks at everything else. Is there a likelihood that people will be deceived? And even a significant minority of people. That's part of our deception standard. Not just the savviest people who are cynical and expecting to be, you know, it's your aunt, it's your sister, you know, even your savvy tech friend who trusts you. You know, if you're willing to, you know, if you're not willing to run a campaign to those people, you should, or it makes you queasy, it makes you wonder, I wonder, maybe I should check more, you know, that's not a bad watchword. So that's all I got to say.
Great, thanks, Dean. I want to save time for questions. If anybody has some questions, just go up to the mic and fire away.
Hi, I'm Rebecca Madigan with the Performance Marketing Association. Hi, Tom.
Hi.
And I just wanted to add a couple of comments. Tom and a gentleman by the name of Rich Cleland, who is also with the Federal Trade Commission, did a podcast for us just this last week talking about disclosure guidelines, and I thought it was an excellent discussion focused specifically on what it means to affiliates and bloggers and disclosing. And it's on our website, performancemarketingassociation.com. And I think it separates out from the intentionally deceiving advertisers and publishers, and it talks about, as the average affiliate, what do you need to do to disclose? So I thought there were some great, you know, discussions there. I don't think it's at all mutually exclusive to disclose that you are an affiliate making money from advertising and you have legitimate content on your website. So I just wanted to add that. The other thing is self-regulation. I think that's another really important thing for the industry. That's something that our association, we're a trade association, and that's what we're trying to approach and attempt as well with. We've got a draft code of conduct for advertisers, publishers, and networks, companies and people that state we are legitimate, we follow the law, and there's a lot of business to be had with legitimate, you know, advertising practices, probably more so than the deceptive. It may take a while to build your business, but there's much greater potential. And my own plug, we're having an open meeting to discuss some of these industry issues tonight at 6 o'clock in the Fiore room. There's some signs that will direct you there. So thank you very much for the panel. It was great.
Thanks, Rebecca. We just have 5 minutes left, so keep going.
My name is Paul Kalbach. I'm from a network called AvantLink. And this question and comment is for David. Really appreciated your comments. We took a stand, proactive stand on trademark bidding right from the beginning of our company less than 5 years ago. And it's worked out for us. We feel that the ethical stand was worth it. It's necessary for the industry to do this, et cetera. But a lot of our competitors have frankly not followed those kind of guidelines. And I guess my question is, do you see a real trend toward starting to enforce or take a stand on things like trademark bidding, and how soon can we hope to see significant progress?
I think
Good question.
it's a really good question. You know, we're kind of seeing it right now with the credit card standards, where, you know, early on, as some networks stepped up and said, okay, for business reasons, we have to make these changes. There's always a discussion about, you know, are we going to be changing the industry, or are we going to be creating big competitors who refuse to go this way? Mm-hmm. And, you know, ultimately, it's not an academic decision. It's a real problem because there are different standards in networks. And I think with trademark bidding, the difficulty is that the wind has changed so many different ways. people came out strong against it. Then other people, with litigation that was happening, was saying, well, maybe I'm okay. Maybe Google's going to allow it. Google's not going to allow it. You had people not committing because it wasn't clear for a long time. And even today, the debate is still there. So I don't know specifically on trademark bidding whether or not you're going to see networks taking a big stand one way or another. But what you are going to see is that advertisers are coming down hard now. And good advertisers will pull their accounts from networks if they find affiliates trademark bidding. Yeah. It's really harming their own business, and where they have a search team of 70 people in-house running their own search terms, and they're competing against affiliates that they're paying for that. I mean, that's just not cool. And so I think, again, it's one of these things that you're going to see private industry pushing that harder than maybe the legal side.
Yeah, well, we took we took a strong stand. We used to manually monitor it. About 4 or 5 months ago, we put out a tool that actually proactively monitors, and we don't allow an affiliate to trademark name bid in our network unless the merchant specifically wants them to do that.
Right, and some are. Some merchants are allowing it.
Thanks for your question. Actually, I just want to get to the last 2 questions. Thanks.
Hi. My question has to do with post-transaction or merchants that use post-transaction and my liability as an affiliate. If I'm an affiliate and I push a company who utilizes post-transaction, you're familiar with what I mean, like a company like Web Loyalty, who uses a money-back cash-saving offers type thing after a customer has come from my site to a merchant site, put their credit card in on the merchant site, and purchased what I was sending them there to buy. Am I liable? Is there some disclosure that I should be giving? As an affiliate, my goal is to help a consumer find a specific product, but if that merchant, unbeknownst to me, or even if I find out at some point, is using a company like Web Loyalty, or there's other companies out there, I don't mean to single them out, to use a post-transaction type offer to help them monetize that traffic, what is my liability?
Well, it's an interesting question. Senator Rockefeller's committee has been focusing on this with 3 companies, Web Loyalty, Affinion, and Virtru, and there's going to be, they've kind of backed down a bit and responded to Senator Rockefeller, but they're going to have more hearings next month. So the issue isn't, I haven't read anything about that proceeding that's really singled out or mentioned affiliate liability. So it's conceivable, but no one's really talked about it or mentioned it.
Just as a best practice, how do I go about protecting myself? I mean, there are things like this going on. I'm looking at it trying to say, I want to separate myself from, kind of the scum in my industry. How do I, what sort of disclosures do I do this without, totally confusing and petrifying customers that come to my site, who then are finding an offer for another site, who then maybe has a post-transaction offer further down the list.
I'm already seeing some bridge pages where affiliates are taking some of the disclosures from the advertiser's landing page and putting it on their bridge page, and they're calling attention to it. They're saying, look, this is the product that I'm talking about. This is directly from the advertiser's page, so be sure to read everything on that advertiser's page. And I think it's a reasonable step to say, this is the scope of what I'm talking about. I am not talking about anything else that advertiser might do, and please read the advertiser's terms because they will apply to you. And I think that's a reasonable first step that you can take to mitigate the risk of someone coming back to you and saying, hey, you should have known what was happening on that advertiser's page and you said nothing. It's the whole blind eye thing. Right. And I think it's going to work up and down and sideways in the chain.
We can discuss it more offline. We're out of time. I just want to get to the last question. Thanks.
Hi, mine's actually fairly specific and quick.
Okay.
I am curious about Mach newscasts as advertising, and if any of you could point me in the right direction, because I'm a little lost here as to the legality of you doing that.
Well, again, that's a deceptive, kind of a deceptive format issue, and there's a difference between having something that looks like a freelance news person just talking about the latest developments. That's all over the internet, and there's a difference between that and actually putting up what looks like a particular branded TV station or branded newspaper that does not, in fact, exist. I'll let Dean speak to some of those examples, but you can't throw up something like the latter and then have a fine print disclosure at the bottom saying, there's no such TV station or something. Dean?
Well, again, net impression, I mean, is the watchword, I mean, if it's an ad, if it's an ad, then that impression has to be that, and people know it's an ad. It's not, and well, I'm not sure what I can add to other than that.
Yeah, it's really the facts and circumstances. It's very fact-driven. You have to look at everything on the page and decide, how deceptive is it? Is it really a material enough misrepresentation that's misleading consumers and causing them to get injured? There's a difference, again, between a legitimate, news, freelance news person just putting up their own stuff as news, and that's fine. But when you cross the line and start, deceptively saying you are WCYN or KLOM, and creating all the monikers and indicia of a actual TV station when in fact no such station exists, you're not going to be able to cure that deception with a fine print disclaimer. I think the first
more common sense again.
Yeah, again, it gets back to the common sense. One of my first questions from one of the first affiliates I ever spoke with over a year ago was, so how can I make my blog more compliant? Well, you can't. Yeah. So,
and part of the logic of this disclosing the material connection stuff in blogs and stuff is that people put a different weight of credibility. Statements have different credibility, whether you think they are some independent news station speaking them versus this is paid for, Right.
Yeah, the reliance on a freelancer's newsletter or weekly news page is different than a consumer's reliance on a broadcast news TV station that in fact doesn't exist.
Okay, fantastic. Thank you.
Sure. Thanks a lot, everybody. We'll stick around for questions. Thanks.